and we have two excellent perspectives to help us do that. Let me introduce my panelists today. We have Priya Sinha. Priya is an Priya is an intellectual property leader at the University of California, San Diego, where she manages one of the largest academic patent portfolio in the United States and helps translate cutting-edge research into real-world impact. With nearly 3 decades of experience spanning engineering, law, and startup ecosystem, she brings a pragmatic, systems-driven approach to building and scaling IP strategy. Priya is also an endurance athlete, drawing on the discipline and resilience of ultra-distance racing to inform her leadership in complex, high-stakes environments. Let's welcome Priya.
Thank you. Thank you for the introduction. And because I am required to say this, my lawyers will be very upset if I don't. Nothing I say today is reflective on the opinions of the university, the regents of the University of California or University of California, San Diego. Thank you. Thank you for the welcome.
Thank you. Our second panelist here is Kirk Sigmon. Kirk is a founding partner of Keldan, an IP, AI, and tech-focused law firm. So from DC to Tokyo, Kirk helps companies tackle complex technology challenges, from high-stakes patent prosecution and litigation to portfolio development, cross-border licensing, and maximizing IP value. His practice spans technologies from artificial intelligence and autonomous systems to video games, fashion, and consumer products. A former Edison Fellow at George Mason University, Kirk is one of the foremost authorities on AI and machine learning. Kirk is also the developer of Patent Agility, a free and open source AI-based patent analysis toolkit. Now, between strategy and execution, this should be a very insightful discussion. So let's get started. So Priya, let me start with you. There's a lot of discussion around AI, but in your experience, how much of it is actually translating into real adoption within IP teams?
Yeah, thank you. The adoption has been slow, and it's happening really in the unsexy layers of IP first, right? It's happening in places where scale and speed is important. So, for example, what is real is prior art search, right? That's a place where we're adopting quickly. Docketing and workflow automation is a place we're adopting quickly. Data analytics and portfolio analysis. Where it is not real yet is in decision-making places. And we've all read those horror stories where not just IP lawyers, but other lawyers have released their decision-making capacity to whatever the AI is or AI agent is and has gotten in trouble. So it's happening for things that we can automate, but decision-making still is something we're looking at.
Okay. So Kirk, there seems to be a gap between what's possible and what's being adopted. So what's really holding teams back today? What do you think?
Well, one of the biggest areas is that naturally, lawyers and writ large, we are all very conservative in the way in which we approach technology. We're nervous people. By definition, we want to avoid risk. And what I mean by that is that we don't necessarily want to trust things until we see them performant. AI inherently, by virtue, I mean, natural language processing tools, regression models, classification models, that sort of thing. They all have a degree of risk to them. They have a degree of imprecision. So getting the legal world comfortable with these tools has been a bit of a bear. Not to say that they're wrong in doing so. In fact, I think that the unsexy use of it is actually the right way to go about it, is to use it sort of carefully and to iterate it out as it makes sense. But needless to say, unfortunately, at the same time, we've seen some overpromising from vendors who would love for you to, believe they can promise the moon and the stars. They can't necessarily do so. So there's on one hand, you've got people who are understandably and naturally very nervous about the implementation of AI. On the other hand, you have people who are perhaps overpromising what it can do. And the reality is we're coming to a shared central point where we're seeing it rolled out slowly but surely in ways that make sense. And ultimately, it's going to change the legal profession, but perhaps it won't change everything about the legal profession.
Yeah, yeah. And I think so when I see you are actually building an AI too. So, what are people getting wrong about AI and IP today?
I could go into a long spiel on this, but I'll give you the basic takeaway, which is that the vast majority of people using it want to wrap conventional LLMs, so ChatGPT, Claude, etc., with the promise of doing legal work. And the reality is those tools are not very good at doing that. They're not very good at factual stuff anyway. But at the same time, there's other ways to use AI that's much more intellectually sort of valid and that can help us more immediately. So the cool, easy, low-hanging fruit is the stuff that we should be going after. Whereas I think a lot of the vendors want to be flashy, they want to be impressive, they want to promise, say, legal brief drafting with a one push of a button. That's sort of unrealistic right now for a variety of reasons. So what we're seeing in some ways is candidly, the misunderstanding of what tools should be used and how they should be used. But I think that thankfully the industry is coming back to a point where people are being realistic and they're getting it in a way that they perhaps didn't say 1-2 years ago.
Right. Now, I think so. Priya, Kirk sounds very, he's talking about things which are achievable, what we should be looking at. But from a leader's perspective, are organization comfortable taking that level of risk yet?
Yeah, it's really interesting because if you think about AI now in 2026, right, we're only 3 years from the drop of ChatGPT. I think one of the interesting pieces about this is that AI is not truly generative yet. It's still machine learning. It's big machine learning, right? But it's still machine learning. And I think when we think about this, I think, as I'm talking to my team, is that we still need to know what we're doing. We need to understand our boundaries. We need to understand our projects, and we need to tell AI, chat, Claude, whoever you're using, or whatever agent you may be using, what it is that we're doing. So, before AI, the question was, or the project is, are you right and are you thorough? Now, since AI has come into our teams, it's, are you right? Are you fast, right? What can you do quickly? Are you strategic? Because now we can run big data sets and understand what we are doing. So can we be more strategic about how we're looking at things? And can you explain to your business partners in a more strategic way what you are doing matters, right? So that has been interesting. I think as we move on, IP folks are going to be operating more like business. I often say when I speak is you can't divorce business from IP. There's a corner of intersection, but I think we'll be able to take on more of that intersection as time goes on.
Right, right. And I think you briefly touched about, adoption in the team. So how do you think, the teams had to change in last 2 to 3 years because of AI? I mean, what changes have you seen especially in the IP teams?
We are, look, every law firm that I deal with is looking at some AI agent, right? Everyone is looking at it in all of the things we talked about earlier, right? Prior art searches, landscape studies, docketing, everyone is looking at it. In fact, I am internally now looking at what I can bring in-house for patent prosecution. But again, it's early. We're early in the stage. So, there's still benchmarking to be done.
Yeah.
I don't think we can get rid of our human calculators yet.
Right. Now, from what you are seeing on the ground, are teams actually ready to make that shift? Do you see a conscious effort being made by the IP teams to start looking at various different tools at various different stages? What could help them do things better, faster?
I mean, I think in the IP space, right, we've been doing that even before chat dropped, right? So if you think about 20 years ago, where we were trying to automate the shells for office action responses. I mean, from a business perspective, you have to move forward. And remember, IP is a part of the business. And if you're looking at commercialization, if you're looking at licensing, however you're looking at it as being part of the business, you've got to use the tools to become better. And yes, I do think people are adopting.
Okay, all right. And so, Kirk, where do you see AI genuinely replacing human efforts in IP workflows? And, so do you think the human expertise is still, irreplaceable, or you think there are areas where AI is definitely making that change?
Sure. So it depends on the classification of the model, really, in some ways. So the basic answer is no, I don't think it's going to replace attorneys anytime soon, but we'll be certainly doing different kinds of work. So your natural language processing toolkits are fantastic for, for example, we've all used spell check for many years. We're seeing more advanced forms of that pop online that are much more adept at finding errors that we might have not found ourselves. That's the good example of stuff that will save our time, right? It used to be back in the day when I started my legal career, you would spend hours and hours poring over a document to make sure there weren't little typos. Ideally, we're getting better from a technological perspective at catching those such that we wouldn't have to spend that much time. We probably still should, but notwithstanding that. On the data processing front, candidly, we should not be doing doc review like we used to in the past. Ideally, we're better at that now, where we don't need to hire teams of people in a basement like I used to run to go review millions of documents at once. That's sort of as old hat. That's probably a waste of time and money when you can go into a litigation and agree upon, say, a semantic search approach to find the document you're looking for. The fear of missing the correct keyword is less of a concern when you can search semantically rather than for a keyword. So that's kind of the spectra of things we're seeing that are very useful. On the other hand, when we're talking about legal judgment, when we're talking about taking into account real world considerations, will we be using AI tools to help inform us? Certainly, but the ultimate judgment is in many cases still, human based. There are nuances that we have to bring to the picture that you can't program into a set of rules, whether or not that's implemented in LLM, right? A set of rules and if/or statements is not going to get you where you want to go when it comes to nuanced legal judgment. But we sure as hell can be making more intelligent decisions when we get there.
And I think what I see is that if I look at the entire legal industry, IP has been where we started adopting automation quite early. As Priya said, there were forms, auto-generated forms which were coming up. Now we have auto docketing where we could directly get the docketing into our systems without any human intervention. So we've seen the automation doing really well with IP, but I think because of certain discussions over the last 2-3 years, we are still there right now trying to get into a vast use of IP, you can say, AI in IP. Okay, now so Priya, again on the IP teams, they're actually restructuring around these AI capabilities. And do you think there has been any restructure in your areas, your department as well, where you see new people with AI capabilities are coming?
Yeah, so I was actually thinking about this, and I made a list of things. I think now we think about AI gives us some options, but not answers, right? So we've got to have the skill to understand which of the options are the correct options, or none of them may be the correct options, right? So yeah. I think I'm going to piggyback on what Kirk said, is that we still have to exercise independent judgment, prompting and interrogation skills. Look, garbage in, garbage out, right? Let me say I'm 58 years old. The first computer language I learned was Fortran 77, and that is what we learned. Garbage in, garbage out. It still applies today. So technical and legal synthesis, I can say to Chat or Claude or whatever we are using, give me an idea of this universe. But how do I then take that universe and put it into something that is useful, right? So again, independent skill is very interesting. I think the one place that I am using it, and before we joined, I was just telling you that seeing trends in big portfolios, right? So my portfolio is almost 1,200 patent families, and looking at those patent families and thinking about what I'm going to do next year is something that has become magical for me. So I think that's important, and and lawyers always have done this, and I think it still remains important, is how to communicate what we've learned to non-lawyers. Less valuable, I think, is drafting. I mean, I think you can drop in a first outline of a draft and probably an agent. I wouldn't, you need an agent, right? You can't just do it in chat or Claude. You need an agent. And I think that first draft is where it's going to buy you speed, and but you still need someone to look it over and see what you're missing. Having said that, I'm going to say, since I've been in the market for some agents, I've noticed that AI is coming up quickly in the physical sciences where I sit, right? And I think it's easy because the folks who are developing it, they understand the physical sciences. I think it's going to become more interesting as we start evaluating the life sciences. So yeah, it's like I said, the value isn't in the first draft anymore. It's like, what should be the first draft? What should it look like?
Right. Because do you think, Priya has touched the topic about drafting. So do you think right now we have a drafting tool, and irrespective of what the technology is, you put your invention disclosure and it will give you the first draft. Do you think with AI, we are moving to a place where we could have technology-specific AI tools, which are, so there could be one for pharmaceutical, one for high tech, one for mechanical, just focusing only on that domain?
To a certain degree, yes, but I'll get into some of the nitty-gritty here to give an example of why we have to exercise caution. So on one hand, the basic answer is yes. I mean, if we're talking about a good starting point for understanding things more quickly, absolutely. Will it draft properly? That gets dicey. And the reason I say that is because if we're talking about a prior art issue, say 102, 103 in the US parlance, can we use natural language processing tools / AI tools to say, compare vectors between two different documents and say, here's what's missing, here's what's present? The answer is yes. In fact, we have tools that do that already. So you can have tools, and they do exist already, to quickly tell you, hey, look, on a procedural semantic search basis, this is the difference between, say, your claims and what has been cited against you. And that's very valuable to give you a starting point. I have tools like that. I've developed them myself. You can also use that, by the way, for finding antecedent basis issues. You can use that for a variety of very cool things. So that's great. Where things begin to fall apart is where the nuance hits. So, for example, if we're talking about not just antecedent basis, but the examiner's perspective of whether or not you've sufficiently disclosed something, well, that's kind of a subjective decision. The bigger issue, and the one that I think is critical especially in my space, which is more computer science and electrical engineering, is the area of 101. So subject matter eligibility, what a human could or could not do. Or even in the 103 domain, again, with prior art, what would and would not have been obvious to one of ordinary skill in the art. When we get into more subjective domains, you can make those arguments. And in fact, I have evidence that the USPTO, at least, has been using AI to sort of formulate the beginnings of those arguments. But the problem is that there's sometimes missing logic there, or there's a nuance or a je ne sais quoi that's missing from those arguments that I think you do have to have human intervention in, because they don't devolve into, say, the comparison of claims versus document or document versus document. They come into the question of, well, what would we say, for example, is something that is within the domain of what the government wants to grant in a patent? Well, we can look at the MPEP or equivalent and talk about that in an abstract sense, but most examiners don't know. Most of the law is sort of unclear on it to some degree. The standard has changed, especially in the last year. That's where human involvement needs to be made. So one way to think about it is we've gotten better and better tools for getting you to a good starting point and giving you a bigger perspective of what's out there and what you need to know as a drafter to create a persuasive argument. I do not think we're anywhere near the point, technologically focused or not, technology specific or not, where we could push one button, have an automatic draft of a response, and then magically have it pump out, what you can file. Like that would just be sort of dangerous from my perspective.
Right, right. I think 3 years back, we started, listening about all the AI tools coming in, and there was one concern there at that time was about hallucination and accuracy. And I think that concern is still there with the other tools also coming. So how do you think, Kirk, how can we design a system to manage that kind of risk, especially in the legal context here?
It kind of depends on what hat I'm wearing. So if I'm speaking as the Dartmouth graduate student, I would say, well, we've got retrieval augmented generation. We're better at that. Hallucinations are less likely, yada, yada, yada. The reality is, as the lawyer, I tell you, we're still seeing them. And I'll give you a very simple example. So I did some testing recently of drafting tools for my own education because I'm not developing them myself. I don't do the actual LLM-based drafting. My code is very different. It's more task specific. So I was reviewing them and I realized that a lot of them, they were better at not hallucinating the law. But what the problem was is that they were using the law, I would say, incorrectly and using it in a manner that didn't necessarily make sense. So it's not a hallucination like we see in the news where it's like, it made a completely fake case. That's not really what's happening anymore. It was misunderstanding the way in which it should have structured an argument for maximum persuasiveness. In this case, for example, one of the things I remember off the top of my head is that the 101 argument was using correct law. It was citing the correct portions of a decision correctly for the 101 argument it was trying to make. But I would have never made that argument because A, the case was antiquated relative to other better arguments. And then B, like I would know that an examiner wouldn't find that particularly persuasive in the context we were in because we were discussing something a bit different than what that case was being used for. So it's one of those situations where the hallucinations aren't coming in the way you see, big ticket on the news, like, lawyer censured for using fake case. Like that exists and that is there. I'm more concerned about even in the world of RAG and things like that. That doesn't mean you're in the clear. It means that sometimes you're still using real world facts, real world information in a perhaps imprecise, imperfect way. That still scares the hell out of me, and I don't like it.
Yeah. Yeah. Okay. Yeah. Now, so Priya, from a practitioner standpoint, where does the responsibility ultimately sit? Even with all the safeguards in place, do you think the legal teams can realistically rely on all the AI systems?
I agree 100% with Kirk. I don't think we can rely on it in any way. We can't take independent judgment off. And, the risk really lies with the drafter. So as I speak to my counsel, or even if I were still practicing, if my name goes on it, we bear the risk. And every bar association in the United States will tell you that if you file something, you bear the risk of whatever happens to that filing, right? So I would not, if I were in private practice still, I would not trust anything that was developed without sitting with it first. And so, I do think there's some benefit when it comes to drafting applications. I agree with Kirk on the prosecution end, but I do think, and I'm going to limit this to physical sciences because I have not kind of done my own benchmarking in the life sciences space. I think, what you have to be careful of is super narrowed claims, for example, right? So the agent will say to you, oh, here are all the pieces of your invention. I have a 3-sided widget and one side is red. It's going to give me a claim for a 3-sided widget with one side red instead of asking what are the parameters and what also exists, right? So I do think that I think it's a good starting point. I think it does increase speed, but it is a risk. And if I were in private practice, I certainly would not go into it blindly. Even now, as I'm considering bringing some work in-house, I still have to work on benchmarking. So I will still have lawyers. I won't send them away. I don't think we're 100% reliable. I don't even think we're 50% reliable yet.
Now, looking at all this, I mean, there are three approaches which an IP team can take. Either build these AI tools internally, look for a reliable vendor, or just wait and watch and see how things are unfolding in next 6 to 8 months, 9 months, or maybe a year or so. So so how should the IP team be thinking or adopting these things? What would you advise the upcoming IP teams? What should they be doing?
I don't think we have the luxury of waiting. We are a small team. We do a lot of work, and I think that's generally true of most in-house teams. I think the more that we can automate, the better off we're going to be. So I don't think we have the luxury of waiting. That's my opinion. I also, we're an IP team. We are not going to innovate on this. We have other work to do. I do think it's important that we keep an eye out on who's out there, what they are doing. I have to say, I get people approach me at least once a week. I have this new whatever it is. I have this new agent, I have this new IP. And I have to tell you that the biggest issue that I'm facing right now is using how much computational time am I using? And are you going to charge me for computational time? And why is that my problem? And, go develop your business method or your business on how you're going to sell this to me. So I think we are now in the process of evaluating a certain agent. We'll see how it happens. They're not charging me for computational time, which is a huge deal. So I don't think we have the luxury to wait. And as someone like me, our portfolio is going to increase 5-6% year after year. I don't have the luxury to wait. So I am actively looking, and it is a tool. It's kind of silly not to evaluate the tools that you have at hand to make your life easier.
Yeah, absolutely. And so, Kirk, looking at how things are moving, how things have moved in the past, what do you think 3 to 5 years from now, what part of IP work will look fundamentally different?
So honestly, I think Priya hit the nail on the head here. In many ways, in my view, and this is just my view as someone who started a firm because of this, it's the responsibility of those of us in law firms to meet the clients where they need us, right? The goal here should not be let's make in-house or university IP teams do a bunch of different things, because from their perspective, they're already overwhelmed. Law firms just need to reorient themselves to how they're operating. Outside counsel needs to meet the needs here, and in some ways that means we need to be using these tools to lower our prices and to sort of use these tools where we can be effective, so that way we're providing better service at the end of the day. So one of the biggest things that I believe, and part of the reason why I have the toolkit that I do, is I believe that we should be using the tools for free. I've developed them for free. They're open source. They're online. The reason for that is because, from my perspective, yes, there's computational time and there's silicon we're paying for. But remember, this is a universe in which lawyers at some firms are charging $1,000 an hour for their services, and they shouldn't be, but they are. So if we can shave off time by spending $100 on computational power on our end, and not pass that over to the client, just be faster, well, then that's something we're sort of expected to do. I mean, the market's going to push that price down on our services, not because we're worse or we're spending less, we're doing something bad. It's because we should be saving the time where we can to meet them at that point. And so, in some ways, I think that a lot of companies are a lot of law firms specifically are trying to maintain this old school hourly model that doesn't work, while trying to pretend as if they're using these tools, but it just doesn't work because they're charging for that too, and it's a mess. The reality is it's a price lowering functionality that we have to use, or else we'll be priced out. And so what I'm emphatic about is that the tools I'm providing are free, because at the end of the day, it only benefits me to put that pressure on other law firms to meet us in the middle. Like, hey, if I can do it faster and you can too, and you're charging them more, then I win, bye. And that's how we win this, right? So it's exciting for me. It's good. Now, granted, I have as many concerns as anyone else. I don't like the idea of just using an LLM for everything, obviously. But if you ask me, hey, can you use, instead of manually reviewing claims for an hour trying to find antecedent basis issues, I have a one-click solution for that now that I developed myself, which I'm still improving. Yeah, of course I'm going to use that because then I'm saving my client time. They don't have to spend an hour of my time for that doing it. I have an hour of my time back. They save an hour of my time in terms of billed hours. Everyone's happy. I get to go watch TV for an hour or something. So it benefits everybody. But it's going to be an interesting pain point for law firms. I think that I've already talked to some where they don't want to admit this is happening. They would much prefer to be charging those $1,000 an hour. They would much prefer to be doing doc review because back when we were doing that back in the day, that was a lot of money. But things are changing, and people are going to have to grow up on that one, or else they're going to be priced out of the market.
Absolutely, absolutely. And so again, Priya, so if I have to, if I ask you to draw a line today, what part of IP work should never be handed over to AI?
Claim strategy.
Okay.
Claim strategy for sure. Judgment disclosure, judgment. I think Kirk hit on this. There's no way that, whatever the model you're using is going to say, I have a 112 basis, or, and certainly on the prosecution end, what does 103 really mean or 101 really mean? So I think that enablement and disclosure judgment should not be handed over. The calls for, there are points where you're there's some strategy around your patent filings, right? Do you abandon and file a continuation? Do you abandon and file a CIP? Do you file a divisional? Do you, is a family become irrelevant? And those kind of decisions, I don't think should be handed over to AI. And not partly, maybe mostly, is because those are not just decisions on the IP side, but they're business decisions, right? So I may not want to pay a maintenance fee today because it's expensive, but I may be able to get a licensee in a year from now, and that is not so expensive, right? So I think those decisions should stay squarely in the owner's hand, whether it's the attorney owner or whether it's the IP owner itself, right? Ethical and compliance decisions, export control is a huge issue for us, right? So export control, the one thing I'll put the caveat here is where does your data sit? Because if there's an export control issue and your data, wherever the servers are that are doing all of these calculations, if they're sitting in Russia right now, that's an export control issue, right? So we've got to be very careful of that. Not just who's looking at it, but where is the data sitting? So that's an export control issue. Of course, confidentiality issues. Again, so like if my team is using something, there's a couple of things. Is nobody outside of my bucket is learning from what I am putting in my bucket, right? But even beyond that, it's not just one bucket. So I have 100, I have 1,200 patent families. Each patent family has got to have its own confidentiality bucket, right? So that's another issue. I think if you're going to those models, you've got to really consider how you're doing it, but someone has to be looking out for that. I think, yeah, inventorship. Oh my gosh, we have so many inventorship battles. When I was in private practice, I never saw an inventorship battle. Once you get into academia, it becomes a big deal. So, right, who is the inventor? And sometimes those battles don't come to us for years after. So that becomes another issue. So I think those are the things that I don't think should be outsourced. And of course, anything that your name or your bar number goes on should not be outsourced. I mean, that's the bottom line for me.
Okay. All right. We've left with 4 more minutes. So I'll ask a question for both of you. And I'll start with Kirk first. So Kirk, do you think the IP industry is moving fast enough on AI, or are we at a risk of being too conservative?
I actually think in some ways we're moving both too fast and too slow. So the people who should be moving faster are not moving fast. I'm harping on other law firms. I have, I'm that guy who's doing that. But a lot of them are too conservative. They're moving too slow. They institute 5, senior partner panels to review the tools that they end up not using, and they end up purchasing and not really deploying and everything else. So they need to be moving much faster. I mean, I'm happy about it because we're going to eat their lunch, but they probably should be doing better on that because the old school model is dying on them and they're not realizing it. On the other hand, there are people who are going full bore in a way that perhaps is a little risky. I mean, I have seen, and I won't name who, but I've seen some companies, some law firms, and some in-house counsel who are relying on LLMs for, claim decisions, for example. And it's like, that's dicey. That's where you get into some risk. It seems fast. It seems efficient. I get it why you want to do that. You're busy. But at the end of the day, you're going to regret it. Like, you're spending a lot of money on something that you're going to find, if you want to litigate it, if you want to license it, you're going to have consequences. So in some ways, you've got a two-pole system. You've got some folks who just are trying to bury their head in the sand. They're going to regret it. On the other hand, you've got some folks who are trying to over-rely on it. They're going to regret it. Chances are, as with many things in the law, the answer is somewhere in the middle.
So, Priya, what are your thoughts on that?
I
too fast, conservative?
Well, I think, honestly, I do believe, I'm not going to talk about what goes on inside law firms because I've been there and I agree with Kirk. I've been in big law, I've been in small law, I've been in middle law, and I agree with Kirk on all of those things. Usually little law tends to act too fast and big law tends to act too slow, right? So I agree with him on that. I think, for me, I think we're moving, for my in-house, I am moving at the pace that I need to move, right? Small tweaks here and there. What can I do with my disclosures? Can I look at landscape study as soon as this disclosure comes in? And now I know what licensing looks like and potential licensing looks like. And then I can set my patent strategy. I mean, if you think about it, a year ago, thinking about a licensing strategy would take one person about 20 man hours to do on an easy case, right? Now I can cut that down into about 1 man hour. So I think, I think we're moving at the right pace for the right things. Where I think we're moving too quickly, and I don't know if it's too quickly, we're using our judgment, is really prosecution and patent drafting. I just don't think there's enough benchmarks yet to say, I can do this without any oversight. So yeah, I guess I gave the big non-lawyer answer or the big lawyer answer. The answer is somewhere in the middle.
Right. No, I think it all depends upon each team, each organization, what they feel comfortable with, where they're feeling challenges and how they want to move forward. All right, I think we are very close to the end of the webinar. Sagar, do we have any questions at the moment?
Yes, Arvinder, just give me a moment. I was about to send it. So we are now opening the floor for question. If you have any question, type in the Q&A option. I can see one of the question here: should AI be recognized as an inventor or author?
Are they talking from a theoretical standpoint or from what the courts are actually saying? Because the courts are very clear, at least the US courts have been clear that AI cannot be recognized as an inventor or as a creator for copyrights. And in fact, in my disclosure forms, I do ask a question of, have you used AI to form any part of this invention? And then I ask for the specific question that was used.
Yep.
Yeah, following on that,
So,
there
yeah.
is an increasing body of legal scholarship arguing that to the extent that AI is recommending sort of permutations of your idea, those would be per se obvious. I don't know if I'd agree with that or not, but you should be very cautious that when AI is used even as a tool, because Priya's right, like the law is pretty clear on this, that it's a tool that you use, that you are using like you to use Photoshop or anything else on your computer. Same domain as copyright, where you're using it as a way to get a result for yourself. However, I will say there's some persuasive papers that I candidly in some ways agree with, that if it's giving you generic permutations of an idea, then those ideas would probably have been well known, because remember, these models are trained on existing material. So there's a very real risk that it tells you, oh, you should do it on this device, or you should do it in this way. That's probably somewhere in a paper somewhere, and that gets a little dicey. You're almost implicitly conceding that that idea has been developed somewhere. So you got to be extremely careful. It's one of those things where when I hear that inventors have done it with AI, you've got to be careful. And by the way, a lot of people misunderstand how truly, simple AI is. I get about once a week someone calling me wanting to sue their AI boyfriend or girlfriend. So you've got to dissuade them from believing there's a ghost in the machine a lot.
Yeah.
I can see one of the IP Counsel joining this webinar, Jay. So if he has any point to share, we'd be happy to have his thought as well. Jay, just raise your hand if you are willing to go ahead and ask any question or anything to share. Yeah, okay, so we have him.
Jay and I are old colleagues.
Oh, you are?
Okay.
So Jay is muted. Yeah. No.
While we're waiting for him, I may make one point. This conversation we're having about AI now, 20 years ago, we were having these same conversations 30 years ago. Like I've been practicing law 30 years in May. 30 years ago, when the internet was coming out, we were having these same conversations about lawyers who were using brick and mortar and lawyers who were advertising their services online and having cheaper prices. And now, like, this is not even a thing. It's not a discussion. We've just become used to it. So I think this, adaptation of technology and how we practice and how we move. We've already seen one generation of big change in this, in the time I've been practicing.
Right.
Jay
And I think
is asking, yeah, please go ahead.
Sorry, I was just saying that
It's sort of like a Microsoft introduction of, I'm kind of old. It's kind of introduction of, Microsoft Word in the 90s. I guess that time they had a competitor. I forgot the name. It's been so long. And now AI is just another tool. It seems like to me there'd be like 3 levels of review. Maybe human will, for example, in the patent claim context, human will generate a claim, AI will review further. The patent attorney takes a look, again, and finalize a finished product. There was an analogy, I think, Nada Alfagini in the contracts LinkedIn, she called it an Oreo cookie approach. So you have 3 layers: the initial attorney review, AI revision, and the final attorney review. And that's a good analogy, I think, how we can use AI in whatever area of law, or 3 layers of review to achieve the best product.
Right. Thank you so much for those thoughts, Jay.
Anyone else have any question? Just raise a hand and I will. Okay, so I have one more question coming. Okay, we are observing a significant shift among investors who are becoming increasingly cautious about cost and now prefer to prepare the application draft themselves using AI tools, particularly when compared to the fees charges by our attorneys. Wants to know input from our panel on this, please.
I don't think any sophisticated inventor will ask you to do this. I just don't think that's going to happen. Look, I've been working with startups, emerging companies for, well over 25 years. And I have to say, I have led IP due diligence. The last year I practiced in 2022 I probably led I've led about $890 million of due diligence. And that kind of money is not going to be risked. They are not going to risk on, file quickly. Now, you may have some angel investors who don't know better, who don't understand, who will have you do that. But look, we're still filing entities in Delaware. Like this group does not move quickly on things like this.
Yeah, 100% agree on that. I mean, look, there are limited instances in which I understand that certain startups or certain small companies might want to just get a patent for investment purposes. I understand there's some art to that. But the reality is this is a money game. This is one where the investment you put in is going to directly translate into the quality of the patent you get. I have seen personally many, many examples of even when just bad legal representation has resulted in a drafted patent that screwed over multi-million, if not multi-billion-dollar deals. The reality of it is, if you're going to play in this game, in this field, in patent domain, you should be spending the money on it. Now, we can try to find ways for you to save money using these tools to make us faster, but the reality is it is a very bad idea to try to do the self-service thing or to try to cut the lawyers out of it, because at that point, the lawyers are still going to touch it. We're just going to touch it after the fact it's filed, in which we can't fix anything for you. So what I've conventionally told clients who are sort of more cautious about the money is, look, on one hand, if this is something where you just can't afford it, trade secret is available to you, right? You just have to keep this thing a secret. If not, if patent is the way you have to go with this for one or more reasons, then you're going to have to spend the money on it. And whether that means you get an additional investor capital, whether that means you find more reasonably priced patent drafting services, that's part of the reason this firm exists, is to do that. But you've got to do it. Otherwise, that patent might as well be worth only the paper which is printed on. You might as well not even bother with it.
All right. Yeah, absolutely. Sagar, any more questions?
I don't see anyone raising hand or maybe sending any message right now.
Okay.
If you guys have any question, you can always go ahead and email us. You must have my email ID, sagar@drafteddraft.com. Should we go ahead and yeah.
Yeah, and I was saying we would then ask Priya and Kirk to answer those questions for you. All right, I think so we come to a close of this webinar. So I think one thing what I can say is that AI isn't going to replace IP professionals, but it will definitely absolutely differentiate them. And the gap that we talked about today between what's possible and what actually being adopted, that's where the next generation of IP teams will be defined. And the question is no longer whether to engage with AI, but how deliberately you choose to do it. As I said, different teams will have different priorities. So thank you so much, Priya. Thank you so much, Kirk. Thank you everyone for joining us on this webinar today. Thank you so much for this wonderful discussion.
Thank you.
We'll send a recording and any resources to all the registered attendees within the next 48 hours. And thank you for your time today. Thank you, everyone. Thank you for joining in. Bye.
Thank you.
Thank you.
Bye-bye.
Thank you.
Bye-bye.